Good day, Crime Talk aficionados. We have a great show for you today. First, young thugs co-defendants who stuck it out at trial, found not guilty. The jury has the Daniel Penny case, a recap of closing arguments. Ashley Benefied learns her sentence. Jennifer Crumbley's attorneys are right. The case should be thrown out or given a new trial. An egging prank goes bad. I mean, really bad. Let me show you what is wrong with the Utes of America. That's right, Utes of America, like in Cousin Vinny. And we have This Day in Legal History and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can listen to us on any of your favorite podcasting apps. Now, before we get to the docket, go to crimetalksearch.com. Sign up for that background subscription service today. You're going to be happy that you did. And when you do sign up, you're going to be able to do as many background searches on anyone here in the United States that interests you. Literally anyone that interests you for no reason at all other than you're just curious. And you're going to get information as it relates to possible relatives, neighbors, associates, jobs, education, usernames, their social media presence, photos, assets, criminal history records. Do they have any bankruptcies? You're going to be able to find that out. And any judgments or liens. Oh, and find out if they're married by chance. You know, sometimes both female and males don't disclose all that. Let's say if they're meeting somebody new. Check them out, crimetalksearch.com. All right, let's go ahead and open the record now for December 3rd of 2024. Can you believe the year is almost over, ladies and gentlemen? Unbelievable. First, the Young Thug trial. All right, now the long-running gang and racketeering trial in Atlanta that led to rapper Young Thug ultimately pleading guilty in October ended on Tuesday with a jury finding the last two remaining defendants not guilty of murder. Now, DeMontre Kendrick, who raps as Yak Gotti, was acquitted of all charges, and Shannon Stillwell was found guilty only of a gun possession charge. The verdicts came nearly 2 years after the jury selection began and a year after opening statements in a trial, obviously, that has lots of problems. Now, the original indictment charged 28 people with conspiring to violate Georgia's Racketeering, Influence, and Corrupt Organization Act, also known as COCA. And they used song lyrics and social media posts as evidence. Now, Young Thug, a Grammy award-winning artist whose real name is Jeffrey Williams, was set free on probation after he pled guilty in October to gang, drug, and gun charges when negotiations with the prosecutors broke down. Now, Kendrick and Stillwell were charged in the 2015 killing of Devon Thomas Jr., also known as Big Nut, who prosecutors say was in a rival gang. Now, Stillwell was also charged in the 2022 deaths of Shamel Drinks, who prosecutors say was killed in retaliation for the killing days earlier of two associates in the gang known as YSL, which they say was a co-founder by Young Thug. In other killings, prosecutors allege that Stillwell pulled up next to Drinks and shot rounds into the car. Now, Stillwell was sentenced to the 10-year maximum for possession of a firearm as a convicted felon, previous convicted of a felony involving a gun, with credit for the 2 years he's already served and the balance to be served on probation. Now, the prosecutors always do what they do when they lose. We respect the verdict of the jury. Then the defense attorneys criticized the state for relying upon song lyrics, saying they were among the faulty evidence prosecutors slapped together with this cherry-picked social media posts and unreliable witness testimony to create a misleading narrative about young men who turned to music to escape economic hardships and difficult paths. Prosecutors say that Williams and two others back in 2012 founded Young Slime Life, which they say was associated with the National Bloods gang. Now, the artist has a record label called Young Stoner Life. Now, Kendrick is featured on two of the most popular songs from the label's compilation album, Slime Language 2, Take It to Trial, and Slatty, as well as Young Thug's Slime Shit, which prosecutors presented as evidence at trial. Now, Williams entered a risky blind plea, meaning he pled guilty without the agreement on his sentence already being predetermined. Now, the judge let him out of jail on probation with tight restrictions, including a 10-year ban from the metro Atlanta area, except for on certain occasions. Now, this trial has been fraught with problems and delays, and affected the Atlanta rap scene. Now, Williams grew up in Atlanta in a housing project riddled with violence and became a highly successful artist who added his own twist to the modern Southern trap sound that he helped popularize. Along with using lyrics and posts to prove that YSL was a gang, Kendrick's attorney, Doug Weinstein, said during closing arguments that the proceedings threw together random alleged crimes, see what sticks, but did not prove they connected to a criminal enterprise. Now, while the defendants did commit crimes in the past, defense attorneys Max Schrart said it was to make money for themselves in communities stripped of economic opportunity, not to advance a gang, and music lets some of them move on. As a whole, we know the struggles of these communities, he said, and it's a sad, tacit acceptance that it's either rap, prison, or death. Now, Schrart sought to cast doubt on the gang investigation as YSL's associates. The states brought in as witnesses. Several alleged YSL members testified that they had lied to the police to stay out of prison, and Schrart said officers had threatened them with long prison sentences if they didn't say the correct thing. He suggested one witness could have killed Thomas. Now, a prosecutor said those witnesses were honest with police, but lied on the stand in front of the police because they had snitched. And the testimony are corroborated by other evidence, such as songs and social media posts, where they said the defendants were bragging about murder. Now, prosecutors said Stillwell and Kendrick were in the car, and they used in a drive-by shooting that killed Thomas, and Stillwell's social media posts indicate he was involved. Now, the defense lawyer said that there was no evidence that Kendrick ever got into that car, but rather surveillance footage shows he was in his own vehicle around the time of the shooting. Now, prosecutors said that Kendrick switched cars off camera, and that he was the one who told his counterparts where Thomas was, making him liable for the death. The prosecutors and defense attorneys had conflicting interpretations of the surveillance footage of the Drinks murder. Stillwell pulled up next to Drinks' car and fired 3 rounds in the car, then sped away, the prosecutor said. The defense said Stillwell drove away, but Drinks was shot in the car, and there was no gunshot residue in Stillwell's car. Well, jury selection for this trial took nearly 10 months. That's unbelievable. I don't know how it would possibly take 10 months to get a jury in any case, except for this one, apparently. Anyway, and Stillwell was stabbed last year at the jail, which suspended trial proceedings. Kendrick was stabbed Sunday in jail. Anyway, the Fulton County Superior Judge was removed from the case in July after defense attorneys filed a motion to recuse him based on meetings he had with the prosecutors and a state witness without defense attorneys being present. When the new judge took over, she reprimanded the prosecution for being disorganized and not sharing evidence. Now, Brian Steele, Young Thug's attorney, said he wanted to continue with the trial because he believed they were winning. But the rapper said that sitting in court felt like hell and that he wanted to go home to his family. Now, 9 people charged in the indictment, including Gunna, accepted plea deals before the trial began. Charges against 12 others remain pending. Prosecutors dropped charges against one defendant after he was convicted of a murder in an unrelated case. So a couple of things on this case, ladies and gentlemen. First, 10 months to seat a jury, almost 2 years to do the trial. Unbelievable. We brought it to you for a while, but it was so sporadic. Frankly, it was just boring. I agree with the judge. The prosecution sucked in their presentation of evidence, probably had something to do with the not guilty verdicts in this particular case. And it could have been just the jurors just fed up with it and say, screw you, prosecutor. Anyway, they can go back to their boss, Fannie Willis, and explain why they lost the case. But they're going to look at as well, look at all the other people we got to plead guilty out of fear of going to trial. It's a real thing, ladies and gentlemen. Speaking of pressure, let's talk about Daniel Penny. First, obviously, Daniel Penny's manslaughter trial in Manhattan. is with the jury right now, and the defense had to try and convince the jury that he's innocent, only trying to help fellow New Yorkers and retain his freedom and his good name. Bearing down on the beleaguered Manhattan DA, Alvin Bragg, whose soft on crime policy have helped create a precarious state of the law and order in Manhattan, setting the stage for the events which led to this trial. Now, District Attorney Bragg, one of the worst district attorneys in the United States, finally showed his face in court as both sides gave closing arguments. Now, ultimately, it comes down to this. Did Penny, while restraining Jordan Neely in a chokehold, apply enough consistent and sufficient pressure to cause the 30-year-old mentally disturbed man's death? Now, in their closing remarks, the defense argued that the Marine veteran who is trained in chokeholds did not. What happened on May 1st, 2023 was not a chokehold death, said the defense attorney, Stephen Razor. They must prove that Danny actually applied it to the following manner: consistent and sufficient to the point of death. The truth is, he didn't. Now, Razor added that Penny didn't apply such pressure because he wasn't trying to render him unconscious. Razor reiterated the finding of Dr. Chundru, their forensic pathology expert, who disputed the medical examiner's conclusion that Neely died of a chokehold. Chundru said Neely died of a combination of factors: his use of street drugs, K2, his schizophrenia, and his struggle, which triggered a sickle cell crisis in his body. He was not dying due to Danny squeezing him to death. He was dying because he was being deprived of oxygen internally due to his medical condition, the defense argued. Danny could not foresee Neely's sickling death, so he is not guilty. Now, Razor laid out Neely's extensive mental illness, which their expert witness described as severe case of paranoid schizophrenia. Also, his belief that rapper Tupac Shakur, who died in 1996, was using him to change the world. The defense then tried to put the jury in the subway car of the Uptown F train as it approached the Broadway Lafayette station back in May of 2023. He wove a montage of witnesses' accounts, many describing their levels of fear so high they created physical reactions. "You go nowhere because you can't. Everyone was frozen with fear," said Razor, adding that this client stepped up, not knowing if Neely was armed, and he held him in place until the police came. And it took a long time for the police to arrive. Razor brought up again and again the case of the medical examiners ruling Neely's death was a form of a chokehold even before all the tests, including the toxicology, had even been completed. They argued that they submit it was a rush to judgment based upon something other than medical science, he said, suggesting that this case was brought to satisfy protesters. He claimed the video taken by journalist Juan Alberto Vasquez only helped their case and that the government simply did not deliver the goods that they promised. Countering for the prosecution, Manhattan Assistant District Attorney Daphne Yoran tried to paint Penny as someone who had a real blind spot for Neely, and he used way too much force for way too long in the way that he was too reckless in his manner in which he did what he did. D.A. Yoran warned the jury that their verdict should not rely upon whether they themselves would be grateful for Penny's intervention or weigh testimony from the Marine veteran's loved ones who said he's a good guy. What is so tragic about the case is that even the defendant started out doing the right thing, but a man died. He was given all the signs he needed to stop. He ignored them. He must be held accountable. That's the old, there's a dead body, somebody's got to go to prison argument. Anyway, the DA continued, "You're not here to decide whether you want to ride alone on the train with Jordan Neely. That's not what this case is about. The only thing you need to determine here is whether or not the evidence here proves the defendant killed Jordan Neely." Yoran implored the jury to find Penny guilty of manslaughter, a charge which carries a maximum penalty of 15 years behind bars. She told the jurors in great detail how Mr. Neely clawed at his own neck with his nails as he fought against the chokehold in the crucial first few minutes before ultimately urinating on himself and losing consciousness. She described the negligent homicide charge, the lesser of the two, as essentially a fallback charge which should be applied if the jury is not convinced that Penny committed manslaughter. You, the jury, should unequivocally state with your verdict that no person's life can be so unjustifiably snuffed out. She went after Daniel Penny's character and got personal. She said Penny, who has been described by family members as calm, was callous when speaking to the police in a now released video interrogation video. And in the video, she claimed he showed no remorse or regret and lied to police. Now, Penny, who didn't realize that he was at the time a suspect, had willingly spoke to the police thinking he had mitigated a potential disaster. He was not aware of the fact at that point that Neely had even died. Anyway, the DA says our society cannot allow citizens, or the police for that matter, to kill people based upon empty threats, the DA argued, and the defendant could easily have restrained Mr. Neely without choking him to death. After sitting in the courtroom for the last month, it comes down to the conclusion that Penny didn't choke him to death, or whether he did. What happened to Neely is a tragedy, a sad ending for a troubled man who, yes, had a history of violence on the subway, but you could not find beyond a reasonable doubt that Neely's death was a result of Mr. Penny. Well, the jury is out, and we will have to all wait and see what happens. I hope those 12 Manhattanites on the jury return a verdict in favor of Daniel Penny. Yes, he did not know. It's easy to play armchair quarterback and say, oh, you should have done this, you should have done this. But you kind of had to be there. And, well, none of the police were there. None of the prosecutors were there. But all of those witnesses, overwhelmingly, even for the prosecution, said, I'm happy that Daniel Penny did something, because nobody was doing anything, and Mr. Neely was running around terrorizing people. I don't know. I'd find him not guilty. I've been biased on this case from the beginning. I don't think it should have been brought. I think Alvin Bragg is the worst district attorney in the United States. I mean, there are a couple that are a close second, don't get me wrong, but this guy just absolutely sucks. This is a direct response into their soft on crime mentality that they have taken there in New York, where the criminals get out, and yet a good citizen who's trying to do the right thing, who had no intent to kill anybody, winds up finding himself on trial where literally he could spend the next 15 years in prison. That is a travesty of justice. I hope the jury does the right thing. Obviously, we're going to have to respect the decision of the jury. You may not like it, but you got to respect it. And hopefully, if there is a conviction, there will be appellate issues. But let's hope for Mr. Penny. Let's hope. Free Daniel Penny. Hashtag free Daniel Penny. Next in the docket, Ashley Benefied was sentenced. That's right, the former ballerina was sentenced to 20 years in prison for killing her husband, which she said was self-defense. Unfortunately for her, the jury disagreed. Now, back in July, the jury that heard their case deliberated for more than 6 hours before finding Ashley Benefied guilty of manslaughter, a lesser-included offense in the death of her husband. She was initially charged with second-degree murder for the death of her husband, Douglas Benefied, who was shot to death in Ashley's bedroom back in September of 2020. Now, Ashley's attorneys had asked for a downward departure in her sentence, citing alleged abuse in the couple's relationship for Douglas' deaths. Now, the judge who heard the case ultimately denied the motion, and Judge White sentenced Ashley to 20 years in prison to be served at the Florida State Prison, followed by 10 years of probation. Now, she had faced a mandatory minimum of 11 and a half years and a maximum sentence of 30 years. Now, Ashley and Douglas married back in South Carolina just 13 days after meeting in 2016. And after learning she was pregnant, Ashley moved to Florida and began fighting for sole custody of their daughter and accusing Douglas of abuse. Now, after multiple hearings, the judge found Ashley's claims did not have a scintilla of credibility and awarded Douglas visitation in the months leading up to his death. Now, Douglas was killed while helping Ashley move her belongings to Maryland, where they were going to take up residence. Now, during the move, Ashley testified she shot her husband while fearing for her life after he had assaulted her. Now, a prosecutor said that Ashley had no intention of reconciling with Douglas and was moving to Maryland after she had exhausted her legal avenues in Florida to keep Douglas from their daughter. Now, the judge refused to dismiss the charges following a 2-day stand your ground hearing back in July of 2023. And in the ruling, the judge wrote that the evidence proves clearly and convincingly that the defendant is not entitled to court-ordered immunity from the criminal prosecution, as she was not justified in using deadly force against the victim back on September 27th of 2020. Despite the ruling by the judge, Ashley's defense argued that the defendant suffers from battered spouse syndrome. A lot of battered spouse syndrome going around in Florida these days. It's the flavor of the month, I guess, down there. And it's worked 0 for 2 times, ladies and gentlemen. 0 for 2. 0 for 2. Just remember that. Battered spouse syndrome, tough defense to go on. Next in the docket, Jennifer Crumbley. I think she may be right. And boy, did I take a lot of flack for this case, but it looks like somebody else agrees with me. So 10 months after being found guilty of involuntary manslaughter, Jennifer Crumbley, the mother of the Oxford High School shooter, has asked a judge to throw out her historic conviction, alleging that she was the target of an overreaching prosecution that made numerous missteps, including deliberately withholding evidence from her about secret deals it made with school witnesses who testified against her. Now, those deals were first disclosed by the press when a newspaper learned that the 2 school officials who drew scrutiny over their decision involving the shooter had signed a confidential proffer agreement that protected them from having anything they told investigators used against them. Now, those agreements, however, were never made known to the defendant or the jury, which Jennifer Crumbley's appellate lawyers argue in a new court filing was completely unlawful, and I agree. Specifically, the attorney alleges that the school witnesses were hoping to avoid prosecution over their own acts and therefore had a motive to testify in a way so as to shift responsibility towards Mrs. Crumbley and away from themselves. Oh, a motive to fabricate, you say? Oh, how interesting. Not disclosed to the defense? How could that not be turned over in any possible way? And if this, obviously they weren't turned over, but those district attorneys that handled this matter, I would get myself some counsel for the attorney regulation matter. Unbelievable. So anyway, the jury never got to hear that because Crumbley's new lawyer maintains that the prosecution ensured the defense that they were never going to be privy to it. Anyway, these proceedings were tainted from top to bottom and were born out of prosecutorial overreach, attempting to criminalize non-criminal conduct. The appellate attorney, Mr. Michael Desi, writes in a pleading, maintaining that there were no legal grounds to charge Crumbley to begin with. Apart from improper decision to charge, Ms. Crumbley was denied a right to a fair trial, where the prosecution deliberately withheld evidence from the defense, key impeachment evidence as it relates to the proceedings, and a completely inconsistent legal theory that is a grave injustice to the law. Attorney for Ms. Crumbley, Mr. Desi, maintains that the prosecution wrongfully asserted 2 contradictory theories by charging the shooter as an adult, but at the same time alleging the mother failed to control her minor child, the one who actually pulled the trigger and claimed the lives of Hannah St. Juliana, Tate Miri, Madison Baldwin, Justin Schilling, and 6 other students and 1 teacher who were injured. Now, Desi argues it's inconsistent to portray the shooter as an adult in his prosecution, but then paint him as a minor child in the mother's case. Now, the prosecution can't have it both ways, they argue. Maintaining a parent's legal duty to control their child typically involves young children who aren't aware of the dangers or harm they are causing, not to teenagers like Ethan Crumbley, who methodically planned the November 30th, 2021 high school massacre in his journal, writing that he hoped to kill as many people as he could and deliberately chose to surrender so he could witness the suffering. Desi also cites an investigative report that concluded former Oxford High School counselor Sean Hopkins and former dean of students Nicholas Ajak made crucial mistakes on the day of the shooting. There were 2 school officials who signed confidential agreements early on with the prosecutor's office, as it built a historic case against the Crumbleys in this particular case. He argues their mistakes include letting the shooter returned to class despite receiving multiple warnings about his behavior hours before the shooting, not searching his backpack, which contained the gun, and not requiring his parents to bring him home after discovering a violent drawing he made of the gun, a human body bleeding, along with the words, "The thoughts won't stop, help me." Now, the point of the highlights of these investigators' findings is not to prove the criminal responsibility of Hopkins and Ajak. Rather, these findings merely demonstrate why Hopkins and Ajak were given proffer agreements in the first place, because they had obvious criminal exposure, attorney writes in his briefs. Now, Desi, the attorney, submitted the filings with the help of law students from the University of Detroit Mercy School of Law, which assisted him in taking the first formal step to have Jennifer Crumbley's conviction thrown out. Jennifer Crumbley's convictions for involuntary manslaughter stem from a trial riddled with legal errors where key evidence was withheld and cooperating agreements were peddled and suppressed to secure testimony for the prosecution to convict an individual who committed no crime. Now, Desi said in a statement on Monday, adding that he outlined several legal errors that cast serious doubts as to the legitimacy of this sham prosecution. Now, who was the other guy that thought this was a complete overreach and be careful what you wish for when they start using unique, novel legal theories in which to go after people for the responsibilities of their children? Yeah, I think it was this guy. That's right, this guy right here. Anyway, there's a reason why no parent in America has ever been held responsible for the criminal acts of their child in relation to a school shooting. It is because Mrs. Crumbley committed no crime. The case should be concerning for parents everywhere. Now, the prosecution allegedly failed to turn over exculpatory evidence or evidence that is favorable to the defendant by not disclosing they had entered into this proffer agreement with two key school officials, by not offering these agreements and recorded interview statements to the defense. The prosecution allegedly asserted inconsistent culpable theories by charging the shooter as an adult. He was also sentenced as an adult while at the same time claiming the mom failed to control their minor child. Under common law, Jennifer Crumbley allegedly owed no legal duty to the victims of the shooting, no more than someone has a duty to act if they see someone robbing a store. Now, their argument argues that this case should never have been charged in the first place, and the prosecution cannot prove that the mother had a duty to protect the student's victims from her son because he maintains no such legal duty exists in Michigan or elsewhere. The prosecution's claim that she does is an issue for the civil courts, not the criminal courts. Now, the court's jury instructions allegedly were flawed as well, in that the judge erroneously instructed jurors that they could convict Jennifer Crumbley without unanimously agreeing to what crimes she committed. The jurors were allowed to convict under one of two theories, by concluding that she failed in her duty to control her minor son, or that she failed to properly secure the gun and consequently gave him access to the gun. The jurors were told they didn't have to all agree on which theory they were to convict under the law, and that's flawed. Maintaining if 6 jurors concluded it was a gun theory and the other 6 went for the failure to control, that would be a hung jury. Anyway, Jennifer Crumbley allegedly had ineffective lawyers at trial as well. Gee, I don't know, ladies and gentlemen. My gosh, 10 months later, I mean, this case when it got charged, these are the exact same arguments that I was making. Now, you have to remember, at the trial court level, the trial court judges, they live in the community, right? They get reelected in that community. They want to keep their jobs. Yes, this whole issue went up to the state Supreme Court, and the court said, well, let's go ahead and go forward with it. But once again, you know, it's the heat of the motion, it's the heat of the battle, the emotion in the courtroom. Judges want to move cases along. They don't want to, you got sobbing victims crying in the courtroom. And, when you go to the appellate level, you get a little more, what's the word I'm looking for? You get a little more serious about the legal implications of what's actually taken place when you remove the emotion of the courtroom. That's why the appellate courts look at stuff on that cold, dark paper. That's all it is, right? Lawyers are supposed to make decisions with neither passion nor prejudice. I said all along, and I took a lot of beating from you all, I get it. This unique novel theory, my God, the Crumbleys, under this theory, every kid that's ever arrested or charged anywhere, the parents should be charged anywhere. So if you have young children, teenagers, heck, and in today's world where the kids stick around to like 26 or something living in your basement, hey, I mean, who's to say they're not children, right? It's scary, ladies and gentlemen, and I get it. It sucks. People want something to happen. Do something. So the prosecutors go and do something that they've never done before, and then it sticks, and they're going to start using it again and again and again, and we've seen this throughout the country. It doesn't take you long. Go down to Georgia for that school shooting. Once again, Dad didn't say, let's go shoot up the school. If that were the case, I'd say they're guilty. But if being a bad parent, maybe being a little scatterbrained, maybe being busy with work is a crime, look out, because anyone in America could be charged for that case. And where does it stop there? I mean, just at crime? How about just other civil? I mean, it just never ends, ladies and gentlemen. I know people are going to say, Scott, but there's 4 dead people. It was a school shooting. I get it. It's tragic. And you charge the kid that did it. He'll never get out of prison. But you don't charge the parents for that unless they said, hey, little Johnny, do you have your gun to go to school today? Yes, then they would be guilty. But if they didn't know about it, how could you be complicit in it if you didn't know about it? And then it also gets into that whole negligence standard. Negligence is for civil matters. Is it reasonably foreseeable? We don't normally charge people with a negligence standard of care in criminal cases. It's knowing intentionally, that type of situation. We'll see what happens. I believe it'll have to go higher through the appellate courts to be resolved. We'll see. Interesting. I think I'm right. A lot of people think I'm wrong. I guess we'll just have to wait and see. I'm not always right. Well, I mean, a lot of the time I am, but not every time. I'm not claiming to be right. I think it's like 98.6% of the time. Anyway, a prank goes bad. I mean, really bad. So a murder case in Georgia that stemmed from an alleged lover's quarrel and egging of the victim's house is being wrapped up by prosecutors with plea agreements being offered and accepted by 2 of the 3 suspects, and another deal waiting for the third. So Sydney Mon and Mackenzie Davenport both pled guilty last month to charges related to the July 2023 shooting death of Jonathan Gilbert. Mann entered a guilty plea for malice murder, and Davenport pled guilty to a pair of misdemeanors stemming from her actions before the shooting. Now, Jeremy Munson, the third suspect, had a deal offered to him and is currently waiting for his attorney to return from some sort of leave of absence to accept or deny the offer. Apparently, he's been made an offer of voluntary manslaughter, but his attorney has been traveling or some sort of leave of absence, and his offer has been extended until December 13th, so there's a possibility that he could enter a plea that day. Now, Mon and Munson, both 18 at the time, and Davenport, who was 19, allegedly went to Gilbert's residence with the intention of egging it, throwing eggs in some sort of revenge act stemming from an ongoing lover's quarrel. Well, Gilbert caught the trio in the act and tried to confront them, which led Mann to open fire on him with a pistol she was carrying. Now, Gilbert was unarmed and his body was left in the street. Now, because they had all plotted and planned together and traveled to the location with the intent to commit a crime that led up to the murder together, they are all culpable as if they each had pulled the trigger themselves. That's a theory of complicity, ladies and gentlemen. They went to egg a house. The victim confronted them while they were doing it. He lost his life, and they drove off and left his body in the middle of the road. Together, they bought that ticket. Now together, they can ride that ride, the district attorney said. Now, Mon and Davenport appeared in court on November 20th to enter their pleas, and Mon was sentenced immediately thereafter. She was sentenced to life with the possibility of parole, ladies and gentlemen. Next on the docket, maybe this video explains where we are as a society. Now, I can assure you, as we start playing this video for you, of this young lady. If I had done this as a child, I wouldn't be here with you. I would be dead, because that's what my parents would do. They would have killed me, all right? If my child had behaved like this in any location, let alone a grocery store, they would be headless, because I would have knocked their head off, okay? So take a look at this. So this little spoiled little girl, two women were seen trying to physically stop the girl, but when the child went on the floor and started kicking, they gave up. Now, after she stood back up, the girl continued stomping started stomping and flinging items ranging from dairy goods to Little Debbie snack cakes. So one shopper asked who the girl was and where they were, while another ordered onlookers not try to intervene. As a larger crowd began to form around the child, more witnesses tried to speak to her and make her stop, but she only intensified her actions. Now, the final straw was when she started smashing bottles of sparkling juice on the floor, causing red liquid to spill out and glass shards to scatter all over the floor. Now, one woman appeared to be defending the girl, yelling at people who were recording, "Don't record her. You don't know what she's going through. You don't do that to a little girl." One man was seen trying to stop her from grabbing any more bottles before the video ended. Now, it's unclear where and when this incident occurred, but it began circulating online on Monday. Viewers generally expressed complete outrage and disappointment with the little girl's parents or caregivers, blaming them for her action. One said, "There's no justification for allowing your child to run rampant and destroy products in a store. This isn't a place to hold a therapy session," one stated. Children acting this way are often testing their caregivers to see if they care enough to exercise some authority, control, and structure, someone said. And the long pattern of intellectual and emotional neglect is often evident when a child acts this way. Other users did not see a child crying for attention, but simply misbehaving. Someone said that parent or grandparent should have to pay for every single item of the Walmart, and they should press charges against for the destruction of property. There's nothing wrong with that young girl, that she knew she would get away with it. People have overused the mental health excuse. Now, the true reasoning behind the young girl's actions is completely unknown. I don't think it really matters. I don't care what kind of issues you have going on in your life. I don't care how neglected you were, anything about that. It doesn't give you a right to destroy other people's things. You want to act a fool in public? Do so, but there needs to be consequences. And going back to the Crumbley case, clearly some bad parenting going on here. Charge the parents. Charge the parents, ladies and gentlemen. They should have known that she was going to behave this way. They knew it. They knew it, right? They should have known that it was going to happen. Charge them. Charge them. So all your mental health, everything's that mental health excuse kind of stuff, charge them. Next in the docket, this day in legal history, 1818, on December 3rd, Illinois becomes the 21st state being admitted to the Union, expanding the U.S. territory and influencing legal and political developments. And where did they go so wrong? That's for sure. Where did they go so wrong? And then 1910, the first U.S. auto theft is reported. That's right. The first reported automobile theft in the U.S. occurred in St. Louis, leading to the development of laws addressing motor vehicle theft. And in 1964, the Berkeley free speech movement arrests. Police arrested over 800 students protesting for free speech at the University of California, Berkeley. This event highlighted issues of civil disobedience and legal rights. Now, what's interesting about this, ladies and gentlemen, is people at Berkeley don't want you to express your free speech. They want you to only regurgitate the speech that they like. And if you don't, you should be canceled. Oh, how things have changed over a little bit of time. 1964. Go back 60 years, ladies and gentlemen. Oh, how things have changed. And finally, our dumb criminal of the day. Take a look at this. A TikTok influencer accused of showing off goods stolen from a Florida Target has been arrested for a second time for allegedly swiping more stuff from the same store. Marlena Velez made headlines last month after she was arrested for allegedly stealing 16 items worth more than $500 from the Target store in Cape Coral, getting identified in part from, well, her TikTok videos she shared that day for her nearly 400,000 followers. She is now facing further theft charges after she was arrested Saturday for stealing from the same store on November 20th, just like our guy yesterday. What the hell is going on? Anyway, police said Velez used a phony barcode to scan items at the self-checkout, pocketing 16 household goods and clothing items valued at $225. She was identified as the shoplifter through surveillance video. and her phone's wallpaper, which matched the phone from her Instagram account. Investigators also said a man with a distinctive arm tattoo, who appears in some of Velez's TikTok videos, was also present during the theft. In her first arrest, Velez had been tied to the crime through security footage and video posted on her TikTok account that showed getting ready with me video from the day of the alleged shoplifting incident that showed her wearing the same outfit and glasses the shoplifter was seen in. Now, the since deleted TikTok video also showed her documenting herself, picking out items inside the Target and placing them in her car after shopping. Now, the TikToker has a lengthy criminal history, including back in 2019 when she was arrested at just 17 on grand theft auto charges for stealing her friend's car. And she was also arrested in July of 2023 for shoplifting at a Walmart in Cape Coral, Florida. Ladies and gentlemen, there you have it. Don't live stream the crime scene. Don't brag about your illegal activity. I mean, my God, who do you think you are? Hunter Biden or something? Jeez, you going to get a pardon? Don't think so, Miss Velez. All right, that's all we have for today, ladies and gentlemen. Have a wonderful day. We'll see you next time on Crime Talk. And remember, the Constitution matters.